All right, good afternoon. This is Chapter 13 in America's Courts. As I normally say, I would recommend that you guys print out the PowerPoint in your module, fourth module, Chapter 13. This is rather a long module. I'll try to go through it as quickly as I possibly can by printing the module out, printing the PowerPoint out. This will give you the opportunity to go ahead and highlight areas that are going to be of concern and focus your studies later on for your assignments and for your exam in the fourth module. So in this module, we're going to be talking about trial and essentially the history of trial and the rules of examination, cross-examination, and the submission of evidence. So, jury or history of trial by jury. The Supreme Court case Duncan v. Louisiana, 1968, the court found the primary purpose behind a jury is to prevent the oppression by government and to provide the accused a safeguard against corrupt or overzealous prosecutors and against the complaint biased or eccentric judge. The concept of a jury functioning as an impartial fact-finding body was first formalized in the Magna Carta of 1215. So the legal principle was transferred to the American colonies and later written into the Constitution, specifically in Article 3, Section 2, which provides that the trial of all crimes except cases of impeachment shall be by jury, and such trial shall be held in the state where the said crimes shall have been committed. The Sixth and Seventh Amendments to the Bill of Rights also codified the right to trial by jury. Sixth Amendment notes, in all prosecutions, the accused shall enjoy the right to speedy and public trial by an impartial jury. And the Seventh Amendment notes, in suits at common law, the right to a trial by jury shall be preserved. So obviously, by virtue of our founding fathers and our founding document, the right to a trial by jury is something that's held in high regard and is a basic and natural right. Protections of trial by jury originally applied to the federal court. However, in the Supreme Court case of Duncan v. Louisiana, 1968, the Supreme Court ruled that jury provisions of the Sixth Amendment were incorporated by the Due Process Clause of the 14th Amendment, and as such, that incorporation doctrine that meant the right to trial by jury also applied to the states as well, and by virtue of the states all the way down into local government. All right. In the next two slides, we kind of go through key developments concerning the right to trial by jury after the adoption of the Bill of Rights. So obviously the Bill of Rights, the Sixth and Seventh Amendment, these are all the court case findings and that are specific to the right to a trial by jury. And you should make yourself aware of these. Slide number 4. The scope of the right to a jury trial. While trial by jury is a fundamental right guaranteed by the Constitution, it does not apply to all people accused of violating the law. We learned that, specifically in like traffic court, minor criminal violations, such as traffic violations, as well as juveniles, have no right to have their case heard by a jury, and we learned why. So. In traffic violations, there are infractions, and in juveniles, we're talking about the parens patriae doctrine, where we try to minimize the impact a guilty verdict would have on a juvenile. In the matters of criminal law where jury trial is not allowed, a bench trial takes its place. A bench trial is a trial, you'll see this again, is a trial that is heard by a judge instead of a jury. In some instances, those accused of a serious crime may elect for a bench trial as opposed to a jury trial, especially like if remember we talked about judge shopping, if the defendant knows or the defense knows that a certain judge is going to be hearing the case, and that judge may be sympathetic to this type of criminal or crime, then then oftentimes they may try to convince the defendant to go ahead and opt for a bench trial. Prior to the Supreme Court findings of William v. Florida, juries were traditionally composed of 12 members. However, the court determined that 12 members was a historical accident and unnecessary to affect the purposes of the jury system and wholly without significant without significance except to mystics. And that was essentially saying that it was essentially just what's the word I want to use? History, repetition. That would be good. So they did it. It was a habit. They had 12 jurors. That habit, they kept going with it. The court found that a 6-person jury used in Florida in non-capital cases was large enough to promote deliberations and to provide a fair possibility of obtaining a representative cross-section of the community. Today, many states have authorized juries of fewer than 12 jurors. Okay. The next slide, again, is back to the text. This talks about trial, the different types. We have trial, bench trial, jury trial, and the differences between how the law actually spells out these processes, and then the differences between the law and actions. And then this next slide in table 13.1, this talks about the different juries, 12-member juries required in felony cases. Again, California is one of those. 12-member juries required in misdemeanor cases. California is one of those. And the ones that are that require or allowed to have less than 12 in felony cases would be Arizona, Connecticut, Florida, Indiana, Louisiana, and Utah. We'll get into that a little bit later on. And then in misdemeanors, there's substantially more. So make yourself aware of some of these cases. We'll go through them here shortly. Excuse me. Unanimity. So the requirement that a jury reach a unanimous decision was adopted in English common law in the 14th century. You may see that again. However, the Supreme Court changed this in a couple of decisions, Johnson v. Louisiana and Apodaca v. Oregon, both in 1972, where it held that verdicts in criminal trials, federal criminal trials, must be unanimous. However, in state courts, a guilty vote count of 9-3 and 10-2 were appropriate. Today, most state constitutions require a unanimous vote to include here in California. Only 5 states permit non-unanimous criminal verdicts, and that's Louisiana, Montana, Oregon, Oklahoma, and Texas. You will likely see that again. Of these, Louisiana and Oregon permit non-unanimous verdicts in serious cases. Juries comprised of 6 members, however, must be unanimous in all findings. So if you have a small jury, there has to be complete consensus between that jury. All right, number 7. Before a trial is convened, jury selection must be completed. So they're talking about the venire process. The first step in jury selection is a compilation of a master jury list. And you'll see this again. Voter registration lists are the most frequently sourced source for assembling the master jury list, sometimes called the master wheel or the jury wheel. Some jurisdictions also use telephone directories, utility customer lists, driver's license lists to create their master jury list. But typically, it's voter registration, and that's what we use here in California. So the second step, once that list has been compiled, is to assemble the jury pool, and that's known as the venire. The venire is called by way of summons by the court, which is a court order instructing the person to appear at the courthouse for jury duty. Because the person is summoned for jury duty doesn't necessarily mean they're going to be selected. Some people are not selected because they can't speak or understand English. They may have mental illness, have felony convictions that disqualify them from service. Others may be excused because of certain exemptions, such as government officials, medical personnel, clergy, educators, attorneys, and full-time students. However, some jurisdictions have been eliminating statutory exemptions. Here in California, they've been doing that as well. So government officials, law enforcement, and I was law enforcement, I got called to jury duty a couple of times. But generally speaking, once we move from the venire process and we go into the voir dire, you're going to see that many law enforcement personnel will likely get removed just by virtue of the perceived bias that they may have during the jury selection or actually serving on a jury, especially if it's a criminal trial. Okay, slide 8. The voir dire, last step in the jury selection, is called voir dire, French legal term for speak the truth. The voir dire involves examination, questioning by the defense, prosecution, and the judge about their familiarity with the case, their backgrounds, attitudes about the facts that may arise during the trial, and their willingness to judge fairly and impartially. Although a juror is sworn under oath to answer truthfully, obviously they don't always do so. In cases where it's determined that a potential juror is found by the judge, prosecution, and defense not to be honest, that juror can be excused for cause. It's supposed to be excused for cause. The prosecution defense enjoy unlimited challenges for cause, and they fall into one or two categories, and you'll need to know these. Principal challenges, excuse me, involve finding the potential juror has a relationship with one of the participants in the case, or fact partial challenges, which involves the juror having facts about the case which would bias them and make them predisposed to a particular finding. So they either have a relationship or know about the case. Potential juror can also be excused without good cause. This is called a preemptory challenge. So the preemptory challenge is the discharge of a potential juror by the defense or prosecution for no tangible reason. But generally they do that, or they limit the amount that they can. The discharge is based on the knowledge of psychology or pseudoscience, a feeling or a hunch or a bias. Both the prosecution and defense have limited number of preemptory challenges that can be used to exclude a juror. Case law has limited the freedom of this, however, to ensure that there is no dismissal based on racial, ethnic, gender, religious, or sexual orientation bias. And obviously, that's something that's needed. We can't have those biases, those what we call extra legal factors be used in the voir dire process. All right, moving on to number 9, slide 9. Serving on the jury. So every year, thousands of citizens in every district in the United States are called to serve as jurors. During the selection process, many courts select alternate jurors from the venire to serve if one of the regular jurors must withdraw during the trial for whatever reason that's approved by the court. Compensation for acting as a juror is minimal, and not all employees are required to pay for the lost time. If you're working for the state or working for a federal government, any kind of government, state government, generally speaking, you're going to continue to get paid, and what will wind up happening is either one of two things. They'll either A, let you keep the money that you get as a juror and offset your money that you get paid to basically match your entire paycheck, or you'll turn that money back into the state and you'll get your regular paycheck. Most jurisdictions use the one-day, one-trial jury system, which is where the potential juror goes through the selection process of one case, and if he or she is not selected, they're considered having satisfied their jury requirement for that year or that period of selection. Sometimes it's a year, sometimes it's more. When the prosecution defense goes through the voir dire, they are looking for potential jurors that may be biased towards their side. They will employ professionals to assist the attorneys in selecting juries through the use of behavioral science principles and techniques known as jury consultants, and you may see that term again. They engage in the practice of scientific jury selection, which is use of social science techniques and expertise to select jurors to serve on juries who are likely to be favorable disposed to one side of the case or the other, depending on who is going to be selecting that juror. All right. Moving on to slide 10. Presumptions and the burden of proof. So presumption is a conclusion or deduction that law requires the trier of fact. And when you hear that term trier of fact, they're talking about the jury or the juror to make the absence of evidence to the contrary. Criminal trials start with two presumptions, the presumption of insanity and the presumption of innocence. So the presumption of insanity requires that all the defendants, the jury, be presumed sane unless sufficient evidence to their insanity is proven. The presumption of innocence requires a trier of fact, the juror or the jury, to accept the defendant is innocent unless the prosecution meets the burden of proof, and we learned what that is. It's beyond a reasonable doubt with regard to those charges. Burden of proof is a requirement to introduce evidence to prove an alleged fact or set of facts. It has two separate burdens. You will see this again. Burden of production and the burden of persuasion. So the burden of production is the responsibility of a party in a legal action to bring forward sufficient evidence to support a particular proposition of facts. All right? I have to bring forward this evidence that supports what I'm saying. Burden of persuasion refers to the parties, the prosecution defense, duty to convince the jury or the juror with the facts in such a way that it favors that party. And that's the basis of the the confrontational type of justice system that we have, as opposed to the fact-finding justice system. So I have to bring sufficient evidence, and I have to use that evidence under the burden of persuasion to persuade the jury that what I'm saying is correct, right? Because we can take evidence from one side, the prosecution, and the other side, the defense, the exact same evidence, and present it in such a way that it gives light to our side. That would be under the burden of persuasion. Obviously, the burden of production is the fact that I'm bringing the evidence forward. All right. Moving on to slide 11. These are definitions, evidence, and rules of evidence. You'll see these again in your test. I'm absolutely certain of this. So what is evidence? Evidence is any kind of proof, more commonly physical or testimonial, that is offered to establish the existence or non-existence of facts in dispute. And there are different types of evidence, and we're going to go through these. Direct evidence, which is first-hand evidence that does not require any inferences to be drawn in order to establish a proposition of fact. For direct evidence would be a victim statement. Right? Circumstantial evidence is indirect method of providing material facts of a case. So circumstantial evidence could be real evidence or testimonial evidence as well. Testimonial evidence is oral testimony given under oath. Real evidence consists of tangible objects such as documents, drug paraphernalia, clothing, or weapons. Scientific evidence, and we're going to get a little bit more into scientific evidence later on in this chapter, is evidence that's gathered from forensic, scientific, and investigatory techniques. Demonstrated evidence serves as a visual auditory aid to assist jurors in understanding the evidence, and the presentation of evidence during a trial is governed by the principles called the rules of evidence. You'll see that again. Rules of evidence govern whether, when, how, and for what purposes certain forms of evidence or proof may be placed before the trier of fact in consideration for the trial. And that happens generally during the early part of the criminal trial when they're going through motions for suppression. And that's when the evidence is going to be presented. And during motions of suppression is when the court will rule on whether or not this evidence is one, tangible or meaningful to the to either one of the sides with regard to its presentation, and two, is legal, was legally obtained. All right. Slide number 12 talks about the different types of evidence, specifically rules of evidence. Best evidence rule, chain of custody, competency to testify. What hearsay evidence is, you will need to know this, which is second-hand evidence. Now, hearsay evidence generally is excluded from criminal trials, except under certain exceptions, and it could be a dying declaration, or in situations where the individual is like for probation, or rather for parole revocation proceedings. The courts will often take hearsay evidence, but there are strict rules with regard to its admission. Relevancy, cumulative or unduly prejudiced evidence, privilege, and lay opinion. A lay opinion is an opinion of subjective beliefs where witnesses are not permitted to give their opinions other than general opinions that are rationally based on their own common perceptions. Essentially, if you see someone slurring the words, the automatic assumption is they're going to be drunk, right? Or when a person is, if they're, kicking in their car door or something, your automatic assumption is that they were going to be angry. Right? Okay, moving on to slide 13. Reliability of the scientific evidence under Daubert. So prior to Daubert, there was rules that were established by the court. The first court ruling was Frye v. United States, and that was in 1923. That was superseded by Daubert v. Merrill Dow Pharmaceuticals Incorporated in 1993. So in this case, the court said the following standards on whether scientific evidence was going to be submitted at trial, and if it was, it had to meet these thresholds. So, is the evidence empirically testable and capable of replication? Has it been published or subjected to peer review? Has had a known or potential rate of error that is acceptably low? Is logical, avoids bias, and has construct validity, and how well the data fits into pre-existing theory, adheres to recognized research methods and to proper sampling and statistical procedures for data analysis, and is generally accepted in relevant scientific community. So, Daubert only applied to scientific evidence. However, the Supreme Court held that expert testimony, technical or specialized, must meet the Daubert test for admissibility. And I use this as an example on the face-to-face. If you haven't seen it, My Cousin Vinny, where towards the very end, really funny movie, but there is some really interesting evidence precepts in that movie. So in that one part of it, he's going to introduce photos of the crime scene, specifically of tire tracks that were used. And his girlfriend happens to have family that is, expert mechanics, and she worked as a mechanic before she had her other job. And so she's questioned to determine whether or not she understands these scientific concepts, and thereby making her an expert in that arena of general automotive knowledge, to be able to testify as to what she's seeing. And it's very broad-based, obviously, but it kind of goes to the idea of Daubert. Even with the protections of Daubert, some scientific evidence is still called into question. And in 2009, the National Academies of Science found that among existing forensic methods, only nuclear DNA analysis has been rigorously shown to have the capacity to consistently and with a great degree of certainty demonstrate a connection between evidentiary sample and the specific individual source. In other words, all of the different types of forensic evidence and mechanisms for gathering this evidence and interpreting it, fingerprints, blood splatter analysis, I'm trying to think of some of the other ones, fiber analysis, all these things, of all of them, DNA analysis was the one that was pretty much irrefutable. Right? Okay, then we go on to some of the issues with forensic science evidence under Daubert: hair microscopy, serology, fingerprinting, compositional analysis of a lead bullet, firearm, tool mark, bite marks, forensic documentation comparisons. So these are some of the issues under Daubert, but you notice again DNA isn't there because for the most part DNA evidence is pretty much irrefutable. All right, moving on to slide 15. Objections to the admission of evidence. Objection is the taking of an exception to a statement or procedure during a trial. We've heard that before. Objection: attorneys on both sides must be ready to submit objections to evidence as irrelevant or hearsay. Irrelevant or hearsay, you'll see that again. So hearsay is an out-of-court assertion or statement made by someone other than a testifying witness, which is offered to prove the truth of testimony. Hearsay testimony is excluded from trials unless it's recognized exception and does not otherwise violate the Sixth Amendment to the Confrontation Clause. So in essence, if somebody asks, what this person, well, what do you think Sandra felt after she got beat up? Well, the other side, the prosecution defense, can go, objection, hearsay. How can she presume to know how X person felt with regard to that testimony that she's about to provide? And so that's third party. That's a perception. And that perception would be considered hearsay evidence. Supreme Court has held that crime laboratory reports are to be introduced as evidence. They must be accompanied by the scientists who generated the reports, so that way that scientist can provide testimony regarding the report, and that scientist is also subject to cross-examination. All right. Slide 16. Steps in the trial process. So, trial officially begins with the opening statements by both sides. They outline what they believe the evidence in the case will prove. Opening statement must be rooted in some degree of fact and provide a roadmap for the jury, which is generally chronologically based. Right? Excuse me. Prosecution is responsible for presenting the case, and we'll call the case in chief. You'll see that again, which are witnesses and evidence to support their case. Witnesses are questioned under direct examination, and you'll learn the difference between the two different types of examination. Direct is the questioning of a witness brought forward by the party conducting the initial line of questioning. So in the case of the prosecution who brings forward their case, all their witnesses, when they ask them questions regarding the case, that's direct examination. Cross-examination is the questioning by an attorney of a witness called by the opposing attorney. So if I called this person up as a witness because I needed their testimony, after I'm done with the questioning, the defense has the right to cross-examine. At the conclusion of the prosecution's case in chief, the defense may make a motion at that point for an acquittal. And that motion for judgment of acquittal is a request indicating that, you know what, after everything that's been presented, we don't believe that the prosecution submitted enough evidence to sustain a conviction as a matter of law. So the motion, they're making this motion saying we shouldn't even have to provide a defense or bring our defense up because there was not enough evidence that was being submitted to justify going forward with our defense. Truth be told, motions for judgment are very rarely granted. All right, moving on to 17. So after the prosecutor rests, the defense must decide whether or not it's going to put on its case in chief or to rest. This is based on the fact that the defendant is presumed innocent and has the right to remain silent, remember, so they don't have to testify. And if they don't have any other evidence to submit beyond what was already submitted by the prosecution, then in all likelihood they're going to wind up resting. So they place the onus of proving guilt on the prosecution, solely on the prosecution. If the defendant does not take the witness stand, they're subject to if they do take it, that witness is subject to cross-examination, and that's the mechanism to get both sides of the story, thereby reducing the bias. Once the defendant takes a stand, the state has the right to impeach the defendant's credibility by introducing evidence on any prior felony conviction and in some circumstances prior misconduct, usually with a nexus to the alleged charge. And what they mean by a nexus to the alleged charge is that there is some tangible fabric or what's the word I want to use, tissue that takes behavior that occurred at one point in time and moves it to another point in time. So if the person is in court for burglary charges and a year ago they had a burglary that was similarly situated where they were found guilty of, they could utilize that and say that this individual didn't learn from it, and the likelihood is high that they were the ones that in fact resumed engaging in burglary as a result of previous behavior. So after both sides have rested, they have an opportunity to make closing arguments. Closing arguments are much like opening statements, and they're statements made by the attorney at the end of the presentation of evidence, which summarizes their case and basically calls for a verdict based off of whatever side is on. So the prosecution obviously would be calling for a verdict of guilty, and the defense would probably be calling for a verdict of not guilty or dismissed. All right, slide 18. At the end of closing arguments, the court provides jury instructions, which are legal principles / rules, and follow with specific instructions on the elements of the crime and the charges in the case and what specific actions the government must prove before there can be a conviction. So every single charge has certain standards that have to be met. So if there's 5 charges, they can't just say guilty, and that means they're guilty for all of them. They have to look at each individual charge, and each individual charge, the judge tells the jury what the legal principles are for that charge and what the elements of that crime are, and they have to be met. The judge and the trial attorneys prepare the jury instructions during a special charging conference that precedes jury deliberations. The judge reviews a submission from each attorney and selects the most appropriate ones to provide to the jury. So once the jury receives its instructions, it goes into deliberations. So that's when they go into the room. Deliberations are the actions of the jury in determining the guilt or innocence of the defendant instances where juries are unable or unwilling to reach a verdict, the judge may decide to call the jury back into the courtroom and read them an Allen charge, which essentially is an admonishment. It's a jury instruction in which the judge strongly encourages deadlocked jurors to continue deliberations until the verdict is reached. So, if the judge goes, wait, you guys haven't been in there long enough to make that kind of a decision. This is a pretty serious charge, blah, blah. Really look at the instructions, look at this evidence, so on and so forth. If the jury is still unable to deliver a verdict, it's declared deadlock, and the trial ends in a hung jury. Cases of a hung jury, the prosecutor retains the option to try the defendant again. Double jeopardy clause does not apply in the case of hung jury because the jury did not reach a verdict. So they can go back and make the same charge. All right. Slide 19. Juries are required to decide cases based on two factors. And you'll see this again: evidence presented during trial and legal instructions they receive. This idea is expressed under tabula rasa, which is Latin for a clean slate. Jurors are not supposed to consider any extra legal factors, and we talked about what those are, which is information not admitted into evidence during the trial. However, beliefs and biases do find their way into the deliberation process. Studies have shown these biases, beliefs, and values of how they affect a verdict. Juries are less likely to convict a defendant on a charge involving conduct in which the juror had personally engaged in the past. Emotional arousal often based on images or descriptions of particularly gruesome bodily harm biases jurors towards guilt. Jurors value some type of evidence more than others. Some jurors are inclined to either credit or discard testimony by police depending on what their biases are. The victim or defendant's looks and demographic also play a part in the juror's decision of guilt or innocence. And so they try to remove these biases out of the process. Once the jury is done with deliberations, it delivers the verdict. And the verdict, obviously, is the decision rendered by the jury on the innocence or guilt of the defendant. If the defendant is found not guilty, they're acquitted. Done. If the defendant is found guilty, the case goes to sentencing. So before sentencing, the defendant may file a post-verdict motion, which is after the guilty finding, which are arguments made by the defense after the jury conviction in the hopes of gaining a new trial. These circle around alleged mistakes at trial. They're almost in sync with appeal, right? So they're not quite an appeal, but they are in sync with it. That concludes number 19. Slide 20 talks about the steps of the trial, and then the differences between the ideas of the laws on the books, and then again, the law in action. I would encourage you to review these so that way you kind of get an idea of how what process actually says and how it actually happens when it goes into courtroom. And the last slide is slide number 22. In slide 22, jury powers and pretrial publicity. So even with jury instructions and the voir dire process, studies have found that juries are influenced by extra legal variables, and we talked about that, based on their community standard. Standards introduced into the justice system result in jury nullification, the right of juries to nullify or refuse to apply law in criminal cases despite facts that leave no reasonable doubt that the law was violated. An example would be jury finding a father not guilty of an assault on a person who raped his daughter following the reading of a verdict. And we've heard of cases like that before, right? As a matter of fact, there was another movie, another really good one, where Samuel L. Jackson is accused of murdering two Caucasian males, and he's charged with that murder. But the reason he does it is because he didn't believe that justice was served when these two people were let go after the rape of his young daughter. So in that case, his daughter was raped, and he took the matter into his own hands. In this movie, he went through the murder trial, and at the very end, in the closing arguments, the jury essentially looked at the closing arguments and put themselves in the Samuel L. Jackson's spot in his place, and kind of believed that they would have behaved or reacted the same. Provisions of the First and Sixth Amendment at times are at odds with each other. So the Sixth Amendment guarantees the defendant a fair trial, yet the First Amendment guarantees the press the right to cover criminal trials. There are times the press provides information to the community that will poison the jury pool with biased information, right? And we see that all the time. In an effort to protect the court's integrity and to provide a fair trial to the defendant, the court may limit media access to prevent prejudicial pretrial publicity. And this is called prejudicial pretrial publicity. Is the prejudicial information inadmissible at trial that is circulated by the media before a trial and reduces the defendant's chance of a fair trial before an impartial jury. And there's three major mechanisms to prevent this publicity. The first one is a gag order or a limited gag order. The next is a change of venue, and the last is sequestering a jury. So gag orders are orders by the court not to discuss a trial with outsiders of the press, and they give that to the jury. Limited gag order is the same, but directs those involved with the case. Change of venue refers to a change of the location of the case to be tried from one location to another. Oftentimes, judges don't like to do that, only because it puts an additional burden on another court, but it is an option. And the third and last is sequestering the jury, is the isolation of jury members from the community until they've reached their final verdict. And when they talk about isolation, they'll literally move these jurors into motels, won't give them access to their phones. They don't get access to TV. They can't watch the news, that kind of stuff. And they can't even talk with each other with regard to the case. So, well, that concludes Chapter 13. Again, if you have any questions, issues, comments, concerns, I would highly encourage you to give me a call, text, or email, and I'll be more than happy to talk with you about it. And we will see you again on Chapter 14. Have a good afternoon, and we'll see you soon. Bye-bye.